Welcome to the Permanent Change of Station podcast, a place where friends can come together, agree or disagree, and still be friends. Join attorney and Forever Miss Oregon, Lynette Perez, each week as she covers such topics as law, relationships, faith, and current events. No matter the issue, Lynette believes it's time for a permanent change of station.
Hey there, this is Lynette, and welcome to another edition of Permanent Change of Station, a place where friends can come together on any topic, agree or disagree, and still be friends. What a novel concept. I started this podcast as a way to discuss a lot of topics that are of interest to me in the area of law, relationships, faith, and current events. I recently did a wonderful podcast with some moms who have adopted children. And as I have been an attorney of record on many adoptions, I would say I have played a role in at least 50 children's transition into their forever family throughout my legal career. And oftentimes there are scenarios where children have been in foster care or they may have never been in foster care, but the parent who has raised them has gotten remarried or has gotten married for the first time, and the new parent is wanting to adopt the children and raise them as their own. In both of those scenarios, biological parent rights have to be terminated in a court context before the adoption can take place. And it also is a third scenario I've also dealt with is when grandparent has been raising the grandchild and wants to have legal rights and adopt their biological grandchild. And then also in that scenario, before that can occur, the parental rights of the child have to be terminated. And so I just wanted to educate a little bit on what are some of the grounds that that judges look to. And I will be speaking in generalities because each state has specific laws. And if any of this resonates with you, or if it's something that you think you want to explore in greater detail, I highly recommend that you consult with a family law attorney in the state in which you reside. And so nothing that I am saying today should be construed as Lynette giving you legal advice. This is more along the lines of educating you on a very important topic in the law and one that many people intersect with. And so what you need to know is that in every state and every U.S. territory, and what I mean by that, these laws in general also apply if you live in the District of Columbia, this district where I was born. It's not a state, but it is a federal enclave, and it's part of these United States. American Samoa, Guam, the Northern Mariana Islands, Puerto Rico, U.S. Virgin Islands, all of those territories also in general have these statutes providing circumstances under which a person's parental rights to his or her child may be terminated by a court. Termination of parental rights ends the legal parent-child relationship. And once the relationship has been terminated, the child is legally free to be placed for adoption with the objective of securing a more stable, permanent family environment that can meet the child's long-term parenting needs. Termination may be voluntary, and oftentimes there are biological parents that never had an intention to be involved in the child's life. I once represented a soldier in the United States Army stationed in San Antonio who had a very casual relationship with someone which resulted in a pregnancy. This individual this female soldier did not want to have a long-term relationship with the father, and the father had no desire to have a long-term relationship with her or to have any dealings with the child. And so he voluntarily relinquished his parental rights. And from the perspective of the soldier, she was concerned that if she were deployed and something were to happen to her, she wanted to ensure that she had a say as to who would step into her shoes in the event something happened to her on the battlefield. And so oftentimes these scenarios are voluntary situations, such as the active duty soldier I once represented, or they may be involuntary, in which the court says, no, I'm stepping in and terminating these rights. Birth parents who wish to place their children for adoption may voluntarily relinquish their rights. When addressing whether parental rights should be terminated involuntarily, the laws in most states require that a court do the following: that the court, and when I say the court, a judge, determine by clear and convincing evidence that the parent is unfit, and also determine whether severing, I should say, the parent-child relationship is in the best interest of the child. Now, the grounds for involuntary termination of parental rights are specific circumstances under which is determined that the child cannot be maintained safely in his or her home because of the risk or of harm by the parent, or the inability of the parent to provide for the child's basic needs. Each state is responsible for establishing its own statutory grounds, and these vary by state. Again, why you need to consult an attorney in your state. However, as a rule of thumb, the most common statutory grounds for determining parental unfitness include the following: severe or chronic abuse or neglect, sexual abuse, abuse or neglect of other children in the household, abandonment of the child, long-term mental illness or deficiency of the parent or parents, long-term alcohol or drug-induced incapacity of the parents, failure to support or maintain contact with the child, involuntary termination of the rights of the parent to another child. So we would see this often in CPS cases. If you've already lost a child, you are already in line typically to put yourself in a situation where they will be actually looking to terminate your rights to any future children that you have. The above factors that I've just listed become grounds for terminating parental rights when the parent has failed to correct the conditions and or behaviors that led to state intervention and is unable to provide a safe home for the child, despite reasonable efforts by the state agency, i.e. CPS, to provide services to prevent out-of-home placement or to achieve family reunification after out-of-home placement. In about 34 states and Puerto Rico, a parent's rights can be terminated if he or she has been convicted of committing sexual abuse or another sexual offense. Doesn't even have to involve your children. If you are convicted of that offense, and it could involve someone outside your home, you are likely eligible to have your parental rights terminated. In 17 states and Puerto Rico, a parent's rights can be terminated upon conviction of child sexual exploitation, including prostitution or child pornography. A conviction for human trafficking or sex trafficking of a minor can result in termination of a parent's rights in 8 states and Puerto Rico. In 26 states and Guam, a man's parental rights can be terminated if he committed rape or sexual assault of the child's mother, and the child was conceived as a result. Being required to register as a sex offender establishes a ground for termination in 9 states. A felony conviction of the parent for a crime of violence against the child or another family member is a ground for termination in every state: the District of Columbia, Puerto Rico, and the Virgin Islands. In 27 states, a conviction for any felony that results in long-term incarceration and requires the child to enter foster care because of a lack of alternatives also may constitute grounds for termination of that person's parental rights. All states recognize abandonment of a child as grounds for termination, while 15 states specifically include cases in which a newborn infant has been relinquished to a safe haven provider or otherwise abandoned. The Adoption and Safe Families Act, ASFA, or ASFA, requires state agencies to file a petition to terminate parental rights with certain exceptions when any of the following apply. A child has been in foster care for 15 of the most recent 22 months. A court has determined that any of the following apply. The child is an abandoned infant. The parent committed murder or voluntary manslaughter of another child of the parent, aided, abetted, attempted, conspired, or solicited to commit such a murder or voluntary manslaughter, or committed a felony assault that resulted in serious bodily injury to the child or another child of the parent. In response to ASFA, many states have adopted limits to the maximum amount of time a child can spend in foster care while the parent is provided with the opportunity to engage in the services required by a service plan to correct the conditions that led to the child's placement in out-of-home care. Many states have adopted the ASFA standard that requires the state agency to file a petition to initiate termination proceedings when the child has been out-of-home care for 15 of the most recent 22 months and the parent has not been making progress in meeting service plan requirements. Some states, however, specify other time frames, such as shorter time limits for very young children. There are some exceptions. While state law requires that proceeding to terminate parental rights be initiated when statutory grounds are met, approximately 35 states, the District of Columbia, and the U.S. Virgin Islands provide for exceptions under some circumstances, including one or more of the following. 1, the child has been placed under the care of a relative. The state agency has documented in the case plan a compelling reason to believe that terminating the child's rights is not in the best interest of the child, and the state agency has not provided the parent with the services required by the service plan to facilitate safe reunification. In 6 states and the Virgin Islands, the court will not terminate parental rights over the objection of an older child unless the court finds the child lacks the mental capacity or maturity to decide. In 5 states, a parent's rights cannot be terminated if the sole reason the parent has not provided adequate care is due to poverty. In 3 states and Puerto Rico, a parent's rights cannot be terminated due solely to the legitimate practice of religious beliefs. In California and Montana, the rights of an Indian parent may not be terminated unless a qualified expert witness has testified that leaving the child in the parent's custody is likely to result in serious emotional or physical harm to the child. A termination action can sever the rights of one parent without affecting the rights of the other parent. Seen that a lot in CPS cases, especially when one parent works the service plan and the other parent does not. However, if the rights of both parents are terminated, the state assumes legal custody of the child along with the responsibility for finalizing a permanent placement for the child, either through adoption or guardianship within a reasonable amount of time. Approximately 25 states have provisions for reinstating the rights of a parent whose rights have been terminated. In 18 states, if a permanent placement has not been achieved within a specific time frame, a petition may be filed with the court requesting reinstatement of the parent's rights. In 12 states, the statutes specify that reinstatement is available only to older children who have not attained a permanent placement. In all cases, the court must determine whether the parent has made substantial progress in correcting the conditions that led to the termination of his or her parental rights and is now able and willing to provide the child with a safe home. The court also must find that reinstatement of the parent's rights is in the best interest of the child, and that the parent and the child both agree to the reinstatement. In 7 states, the state agency must submit a permanency plan to the court with reintegration as a permanency goal, which describes the transition services that will be provided to the child and family to support reintegration. In 11 states, the court may order a trial home placement or a period of supervision by the state agency before the restoration of rights is finalized. In Alaska, a parent may petition for restoration of rights only in cases in which a birth parent has voluntarily relinquished his or her rights at any time before an adoption has been finalized. In Iowa, a petition for setting aside a termination may be made only in cases in which the parent has relinquished a newborn. In Arkansas, Utah, and West Virginia, reinstatement may be considered when an adoptive placement has disrupted. And so this is, again, a very interesting subject. It can be complicated, but like I said, I have had both step-parents who have found themselves wanting to adopt, grandmothers wanting to adopt, people who find themselves incarcerated wanting to allow for a family member to have legal guardianship of their children, have both involuntarily relinquished as well as I've seen them voluntarily relinquish. So all of it above is possible, but know that in general, as a rule of thumb, if you commit criminal acts of, especially of a sexual nature, and or end up in any scenario where you are now required to register as a sex offender, you have pretty much put yourself in a scenario. And just a little side note before I sign off on that, all kinds of things can get you as a registered sex offender. You don't have to necessarily touch anyone. You could be a consumer of child pornography, and then once convicted, you become a registered sex offender. You didn't touch physically anyone, but now you're a registered sex offender, and therefore you have put yourself in a scenario to have your parental rights terminated and to have your children adopted either by a step parent or by total strangers if your case ends up in a CPS case. And so again, a lot of information. I look forward to sharing more on various topics of interest and that I come across in my experience as a trial lawyer. I hope this has been informative, and thank you for tuning in, and we'll catch you on the next episode of Permanent Change of Station.
You've been listening to Permanent Change of Station. Tune in each week for the latest episode on Apple Podcasts, Spotify, or wherever you find your podcasts. You can find PCS Podcast online at pcspodcast.live and on social media. And while you're at it, don't forget to rate, subscribe, and leave a review. This helps others find the show, and we really appreciate it. We'll catch you in the next episode.